Good morning, Chris.
Good morning and welcome back. What are we looking at today?
Today we are looking at the exclusive right to sell listing agreement. How important is this form if you're going to be a real estate agent?
Well, if you're going to be a real estate agent, it's going to be pretty important because they often say that you list to last. So, one of the things that students will learn is that it is important to not only have listing agreements, but to also know how you're going to get paid, know what the duration of the agreement is, and what the relationships are. So, I mean, there's no form more important except maybe the offer to purchase than this form.
That is very, very true. And you already said where I wanted to start with is look, this thing is between the seller and the firm. Because I always like to say the client isn't hiring you, they're hiring the firm. They're hiring the broker in charge. I mean, kind of sort of we could say it that way. It's not about you. So if you get a listing and then you leave the company, it's not guaranteed that you get to take your client with you because it's not your client.
That's right. That's an excellent point. Two things going on. I'm going to go back farther even than Candace did on this and take you to the very first word of this form, the exclusive right to sell listing agreement. So she mentioned it's between the seller and the firm, and it is a relationship that is not to be broken lightly. This is a contractual relationship between that seller and the firm, and you need to understand what the company's policies are in regards to these. Hopefully, you'll love your firm and stay there forever. But if not, there's not a guarantee that you're going to be able to take this with you.
In fact, the seller would be signing it in this last line. The firm may assign other agents in the firm to provide services at any time. So if you leave, the seller has literally already given the firm permission to put somebody in your place and finish that deal. Work on this, this agency agreement, this listing. All right. All right.
Absolutely.
What's our next section? Term of agreement, which that's also important because this tells us when it's going to end. We know all agency agreements must have a start date and they must have an end date. And they can't have an automatic renewal clause unless they are for property management. And you notice there is no automatic renewal clause here. It gives us a firm date that this thing expires at 11:59 p.m. on whatever the date is.
Yeah, and that's if you're watching this as a pre-licensed student, this is one of those rules of agency agreements in Rule 104. So from that standpoint, it's important from a testable topic. But even in the field, this would not be considered a binding contract. If it did not have an expiration date, it would be considered to be ambiguous.
hmm Now, if you were in the field and you're practicing, what would they need this existing agency line for?
Okay, very important here. And this actually brings in not only rules, but it also brings in the code of ethics as well. We have in the code of ethics, it says that as realtors, we cannot, in fact, solicit the exclusive clients of other agents. And that is, in fact, the case. Having said that, every once in a while, someone will call you who is listed with another agent, and they'll say, my agent's not getting the job done. What can I do? Well, it's not our job to coach them how to get out of that agreement. So it's very simple what we tell them. What we tell them is, I would be glad to give you my services when you are no longer working with another agent. So when we talk about existing agency here, if this seller says, well, it runs out in another month, Chris, can you come do a presentation about your services? I can literally go do a presentation based on the fact that they asked me to do it, and we can start that agreement when the previous relationship ends. So what Candace is showing you there is the listing agreement that they are in expires on this date, and our agreement will be effective immediately upon the end of that. Every agency agreement must have a start date and an end date well defined.
I know it doesn't talk about it right here, but I also think it's important to remember if that happens, let's say, Chris, you're listing a house, I'm the buyer, I see it, and then your listing ends. And now Sally Mae gets the listing right afterwards. Even though I saw the house while you were listing it, would you get paid if her agency agreement with, Sally Mae came into effect?
Now, are you asking about the protection clause? Is that where you're
Yeah,
going
the
with it? Oh,
protection clause. Hmm.
yeah, a little bit later, we'll get to the protection clause, and protection clauses only protect the previous agent if, in fact, they have not listed with another agent. But if they list with another agent, you'll actually see a big word, however. We'll have Candace point that out to you once we get there. They waive their right to those previous buyers if if a agency agreement is signed with another agent in the MLS.
Yeah, I know it's not until later, but I think in the real world, sometimes people get their feelings hurt and they don't need to. It's not personal. That's just
Yeah.
the way the contract's written.
That's right. And people misunderstand it, Candace. So it's a great point. We will bring it up a little bit later, but you have to touch on it right here so that everybody knows what their rights are.
Exactly. Okay, so let's talk about this property section. Hopefully, by this point in the class, if you're watching this or you're in, actually in real estate practicing, there is a difference between a street address and then there's going to be some type of legal description where you're talking about, what book is it in? You can see there's like lot and block. That's one way to do it. You're going to talk about what subdivision it's in. Maybe there's some other type of legal description. I mean, I guess it could be meets and bounds if it's old enough. But remember, your legal address, your legal description is not your street address. Those are two different things, and you might as well just go ahead and fill out both on this form.
As I always say on this, Candace, more is better than less. And people can't understand that until they've ended up in a situation where they've accidentally contracted on something that the seller never meant to sell.
Exactly. And you know what? You had a class earlier this week where you talked about this additional parcels section. You tell them now what you talked about then?
Yeah, there was a case that we had where, matter of fact, it ended up in the back of the bulletin, where an agent was supposed to be selling a quarter acre tract of land, and ultimately the buyer thought they were contracted on a 8/10 of an acre tract of land. Pretty major difference there. And the reason is from the street, you perceived it to be one large lot. As it turns out, it was two separate parcels. Now, had they wanted to sell both parcels, that's fine, but you would need to have the legal description, both of them, in this listing agreement, and then conveyed to buyers as well, buyers agents, so they would in fact know what they're doing. And if you have to, guys, check this box and attach an exhibit that shows what you're selling, but don't get lazy on legal descriptions. It's easy to just think that this is, you just kind of phone it in, but it can be very important at times.
Mhm. All right, let's scroll up. And one of my favorite sections of this contract and of the offer to purchase and contract is this fixture section. Now, we know a fixture is a piece of personal property that's been permanently attached to the real property. And now, of course, it goes with the real property if we're talking about residential. And this is the section where we want to have a conversation with the seller about, hey, if you get an offer from a buyer who's using the standard offer to purchase and contract, this is what that contract says should be left. It's a great place for you to have a conversation with the seller about, hey, did you intend to leave X, Y, and Z? You do understand that there are things in here that even though they're not fixtures, we're contractually agreeing that they're going to stay. Like one of my favorites is all the stoves, ranges, and ovens. So if your refrigerator matches the stove, which matches the microwave or something, I don't know. You can take the refrigerator, you can take the microwave if it's not built in, but you would have to leave the stove according to this contract. So you want to have this conversation with the seller. Is there a way to make it so it doesn't have to stay? Yes, and we'll look at that in a second, but I think going over this list with the seller right now, when you're first starting to put the house on the market, is really important.
Yeah, let me mention one other thing. Going back to the introductory paragraph, at the end of the first line there, I need to help pre-licensed students especially understand this. Go just above where you are there,
Yeah.
Candace, and highlight all existing features. Fixtures,
Uh,
excuse me. What this contract actually says is the items below are in fact considered fixtures. And as Candace said, even if it's something you wouldn't normally think of as a fixture, it is a fixture because it says so right here. But that doesn't mean that this list is comprehensive. There may be some other things that are, in fact, fixtures that are not listed here. Well, they still go with the property. So don't tease yourself or kid yourself into thinking that this is a comprehensive list. And also, if there's an item on this list that does not exist in the house, you don't have to mark it out. In other words, if you don't have electrical vehicle chargers, you don't have to mark it out because the idea here is the following items, if they exist, are fixtures.
Yeah. I heard somebody say, well, it says I get the radon fan, so you should put a radon, ventilation system in. And I was like, that's not how this works.
Exactly.
Like you said, if it already exists, it stays. The seller doesn't have to go out and provide all these things on the list.
Perfect.
Right? But we go over this when we talk about the offer to purchase and contracts. So we don't need to do it in detail now. This is more about, guys, just have the conversation with your seller so that you can put the information into the MLS and make sure when you do get an offer that anything that you want to stay that wasn't a fixture or that's a fixture and it's not staying, you just make sure you have that conversation early. It's not going to hurt. All right, so let's jump down. Oh, I do want to jump down here. This is where you would put the personal property. So if you're going to be working with this seller, and what kind of personal property do people leave nowadays? Sometimes washer dryers.
Well, there's almost no doubt that in most transactions, the refrigerator, the seller's probably going to leave it. And as a matter of fact, I was talking to my pre-license class this week, and one of the things I pointed out to them is sometimes in the MLS, it will say seller agrees to leave the refrigerator. But having said that, it doesn't matter what the seller said in the MLS. What matters is what ultimately goes into the contract. So remember, we're in the listing agreement now. Let's go ahead and start that conversation with the sellers and say, hey, what are you thinking about leaving? And you see that Candace gave us some great examples there, the type things that they might typically be willing to leave because these things are a pain to move. Candace, I got to be honest with you, because this is the listing agreements, I put them here, but I usually use them as bargaining chips a little
Hmm.
bit later in the transaction. I don't typically put in the MLS that the fridge will convey, and the reason I don't is if we're $300 or $400 apart, and I know the seller will throw it in, I'll throw it in as a concession just so they feel like they got something.
Yeah, what we do in pre-licensing is just kind of teach you the basics. It's when you get with your BIC and when you get your training that you really learn all the details and how to really use this to make sure you're protecting your client.
Perfect.
All right, next we have the listing price. I mean, Chris, is there any time ever that I would sign a listing agreement with a seller and I would leave this blank to be decided later? Is there ever a time for that?
Well, let's go. Let's stay on pre-license on this one, if you don't mind. And the reason I say that is we tell you the rules in pre-licensing. If you want to go outside the rules, you're running the risk. And here's the problem with this. I have had agents who would say list price to be determined at a later date. Well, here's the problem with that. The law looks at that as being ambiguous, and contracts have to be made on clearly defined terms. So if you have something like to be determined later in that blank, unfortunately, this is not going to be a binding contract. It's not a violation of law to do it, but having said that, that seller could walk away, and unfortunately, all your work would have been for naught until you get the terms clearly spelled out in this contract.
I think an even better reason is because the commission says don't do it. If
Yeah,
the
yeah,
commission tells you don't do it, then why do you want to test the waters? It's like touching the hot stove. Just don't do it. Just
right.
don't do it. All right. And then our next section says, look, the seller is willing to accept payment from a buyer. And then you got all these different options. Now, when you get into class, you'll talk about what all these mean. But why would a seller care how the buyer pays? I mean, I'm getting my money. Why would a seller care about that, Chris?
This is so important, actually. And to be honest with you, it might be more important in the field than it is in the pre-license class. Almost certainly sellers are going to accept cash. I don't know of many cases where they wouldn't want to accept cash. But when you start getting into FHA and VA loans, the property has to qualify. For example, if you're selling a condominium in a complex that's dealing with mostly investors, sometimes they are not FHA and VA qualified. So if you're out marketing that property and someone brings you a FHA offer, you accept it and go under contract, and then find out that they can't get a FHA or VA loan, not only have you wasted time, you've also cost money as well. So you have to vet the properties to make sure that they are qualified. And then you can see there's some other options as well, USDA and conventional. I will tell you guys, we don't have time for it in this class, but if you think you're going to have a loan assumption or seller financing, please get with your broker in charge right away, possibly even an attorney, to make sure that you have the paperwork options to be able to do that.
I mean, from a pre-licensing point of view, being able to know what each of these things are is going to be a huge part of being able to pass that finance section. Again, we're not going to go into it detailed by detail now, but if you're watching this and getting ready to take the exam, you should know what's the difference between an FHA, a VA, USDA, conventional. You should just really know those are great vocab words for the exam.
And one more thing on this, and this is just a fine point probably for pre-license class. When we talk about a buyer being ready, willing, and able to purchase a property, it assumes that it's at the terms of the listing agreement. So, for example, if the seller lists the property for $300,000, if a buyer offers him $300,000 cash, he doesn't have to accept it, but you've earned your compensation because you bought a ready, willing, and able buyer. Clearly, this buyer is able, they have $300,000. But if that buyer brings you a $300,000 seller financed offer, well, the seller is not obligated to sell it, and you haven't earned your commission unless the seller has checked the box that says seller financing, which 90% of the time they will not have done that.
Mhm.
That makes sense.
All right. Next we have marketing. I mean, you're signing this exclusive right to sell listing agreement because this seller wants you to list this property on the MLS and market it. They want you to find a buyer. So if that's what you're signing in the contract, what is this part? Why are we signing this part, Chris? What's important about here?
It's very possible that you can take a listing now because you do want to get the seller bound to your services. However, there might be work that needs to be done before this goes live in the MLS. So you're looking at two different things. The date of this exclusive right to sell listing agreement might be May 1st, but it may not go on the market until June 1st because they have 30 days worth of work that they need to be done. And there are rules in the MLS which are not tested on for pre-license class, but those of you in the field, you need to be familiar with the MLS. But because of the clear cooperation policy, you would have to put this into the MLS within one day. I think it's one business day of the marketing date that's on here. So what it does is allows you, now keep in mind, you can't market before this marketing date. You can have the listing before this marketing date. You just can't market it, but certainly your seller could be preparing the house for
Yeah.
the market.
I mean, I think there's a couple things to point out. You earlier talked about finding a ready, willing, and able buyer. This is what you were just talking about up here, where, hey, if you find that buyer, hey, they don't have to take the offer, but you did your job. The other thing I want to point out is all of this stuff that talks about, public marketing and all of that. Once you get into the field, there are different MLSs. There are different rules for everything. Make sure you understand. This is not the time you want to just go wild and be like, oh, it's better to ask for forgiveness than permission. Absolutely not. Because a lot of this has to do with how you get paid and, not breaking rules and things like that. So guys, make sure you understand just because, you could do something doesn't mean you can do something. You can take a listing and not market right away. But if you don't get the right paperwork for that, you're going to get in trouble. So definitely take a training class on this. And if all else fails, call Chris. His number is, no, I'm just kidding. Do not call Chris directly because he doesn't know all the rules for every MLS, but he's pretty good. He knows a lot of them.
Well, I know our local rules okay, and more importantly, I know where to point you to get the paperwork and stuff like that. I'm coming out of the Triangle area of North Carolina, so I have a pretty decent idea where to find that particular information. But what Candace said is correct, and it may be different if you're in a different MLS. And let me tell you guys, here's a dirty little secret about this. If you mess up on your marketing, it's usually another agent that will turn you in. And a lot of people say, well, that's crazy. Why would another agent turn you in? Well, remember, they might have a buyer who is looking for the type of property that you're listing. And if you're not openly listing it to everyone, they may feel like it was not fair to their buyer. So you have to
Mhm.
follow these rules because if you don't, other agents are watching it very closely as well.
Exactly. Take a training class, one on the contract, one on your MLS rules and marketing. And
Right.
hopefully your BIC is going to provide that. All right, let's go on. I think I'm really quickly going to mention, excuse me, that you want to get permission from the seller that you can put a lockbox on the door. And when you put a lockbox and you have showings and open houses, you want to make sure you explain to the seller that there are risks. You have strangers in your house. You have people coming in and out. So, I mean, everything in life is risky, but we're just pointing this out to the seller. Anything you want to add there, Chris?
Just be careful, guys. Again, there's some things that you kind of phone in and you just like, it's not that important. It's just legalese or whatever. But when we're talking about marketing this property, your seller cannot record someone else's voice while they're in their house. And a lot of sellers are like, well, it's my house. I'll do whatever the heck I want to. Yeah, but earlier this year, we called an agent on an audio saying a bad thing in one of our listings. Unfortunately, what we found out, if our seller was to expose that, they could have criminal penalties against them for exposing it. So tell your sellers, if you want to do video, that's fine, whatever. But if you're going to record someone's voice, you are breaking a state law in North Carolina.
Hmm. Exactly. All right, moving on to fees because this is how you get paid. And Chris, we know you are the number person of the two of us, so talk to us.
Okay. The Because of some changes coming out of the Norris settlement last August, they have tweaked this paragraph and it's very readable now. But I was listening to oh gosh, John Waite did a recording on the new contracts and changes. He works for the association. He's on the forms committee, and he said that there's a way that they expect this to be filled out. So notice first of all, in the negotiable fee there, this language is in there because of the lawsuit. Sellers need to understand where their money is going. Once you get into section B, it talks about how you can be paid. Now, while you could charge a non-refundable retainer fee, it'll be credited to firm's fee at closing if that's what you want to do. I will tell you it's not common in my office. I don't set the rules, so you on that. I can see why someone might do that. On the other hand, it's very common that we use a percentage of the property's gross sales price. Because this will be heard by many people, I am not going to use a number here, but I'm going to use the number X. So let's say, for example, that you are going to receive X percent of the property's gross sale price. Make X whatever you want it to be for your purposes. That's how much your firm is going to receive from marketing this property. Okay. So this doesn't include what's going to be paid out to a buyer's agent. The way they want this form filled out now is for you to put how much you are going to bring into the listing firm for marketing the property. Okay. Now, I dwelled on that. The same thing would apply to a flat fee if that's more common in your office. I just told you what was common to me. And then there's this other box down there that says other fee. You may have things like you may have a transaction coordinator, you may have an office fee, you may have some other fee that you charge if you are on a team. You might charge a documentation fee or something to that effect. If so, put it here because whatever you're charging for your services plus whatever you're getting for the document fee, as Candace says there, the seller needs to know how much is going into the firm for your services. That's what B is for. Are you with me so far, Candace?
Yep.
Okay, as we move into C, we're now talking about how we can compensate other agents, most likely a buyer's agent. Again, I'm not telling you how to do business here, but it's very common that a buyer agent be paid for procuring a buyer.
Can I
Now,
stop you right there for a second, though?
yes, go ahead.
So I just want to point out for everybody listening to this is July 2025. Remember, a lot of the books that you are studying from have a basic scenario that the listing agent took out both it were collected a total commission, and that listing agent paid both a buyer's agent and a seller's agent, and it was standard. What we're going to go over now, which is not yet being tested in pre licensing, is how it's going to happen in real life and the importance of getting it right because of this lawsuit. So I just wanted to point that out because we do get a lot of pre-licensing people. A lot of what you're being tested on practice exams says who pays the buyer's agent commission. Chris is about to tell you about all sorts of options here. But remember, in pre licensing, we're still basically saying, oh, it's just one fee and it gets split up.
And keep in mind that the pre-license class is not about the rules of the Association of Realtors. They're about the Real Estate Commission rules, and they haven't radically changed. And so don't try to overthink those questions. If it tells you one party pays it or whatever, that's fine. You just go with the math on that. What we're talking about here is what's going to happen in the field. And now we're getting to the part where we're going to cooperate with other agents. And by the way, just real quickly, please, guys, please understand. Cooperation doesn't necessarily mean compensation. I can allow another agent to show my property. That's cooperation. Compensation means I'm going to pay them if they procure a buyer, or my seller is going to pay them. I could allow them to show my property with no agreement on compensation. It happens all the time in commercial and sometimes in residential now as well. So cooperative compensation, I'm talking to my seller because this is the listing agreement, and I tell them they have no obligation, but let me tell you what the benefits of paying a buyer agent are. Most of the time, the buyers are scratching and clawing to get into the property. They don't have a ton of money laying around to pay a buyer's agent. So oftentimes, a buyer will opt to purchase a property if they know their buyer agent is going to be paid out of the transaction or from the seller or from the firm, because they don't have the ability to come out of their pocket and pay for it. So they actually prioritize properties where a buyer agent commission is offered. Okay. Now, if the seller doesn't want to, they don't have to, right? But they're going to agree right there or disagree in that last line. Let's assume that this seller sees the benefit of paying a buyer agent or participating in the payment of the buyer agent's commission there. They would check the box does. And now there are two options. So the first option is seller will authorize the firm. Firm is authorized to offer X% of the property's gross sales price or a flat fee to a cooperating agent. In that first box, what they are doing is they're giving the firm the right to pay a buyer's agent. As Candace said, that's really not that different from the way we've done it for the last 30 years. Okay. So if they check that first box, it's going to feel very comfortable to most agents in the field because it's very similar to what we've done. The second box says almost the same thing, except it said instead of the firm paying the buyer's agent, the seller would be directly paying the buyer's agent. At the end of the day, it's not semantic. It's actually important. But the fact of the matter is, the seller doesn't care if you pay the buyer's agent X% or if they pay the buyer's agent X%. It's just a matter of who it's going to come from. But you have two options there: either firm pays or seller pays. And then there's also a possibility as well that if neither of these fit and your firm has a different compensation arrangement, you can just simply attach that policy to this listing agreement, and the seller will agree to follow that, assuming that they enter into this agreement for you. So that's a possibility as well.
You know
Can,
what else I would say
yeah, go
is
ahead.
I think it's a good thing to point out. If you check the first box, this will not be deducted from the firm's fee. And what I mean by that is up above, we said, hey, that's what the listing firm gets. And that's completely different than anything that would be down here.
Yep, yep. That's a great point, and you're going to see that evidenced here in just a moment. But remember, the whole purpose of this paragraph is to make sure that sellers understand what it is they're paying and where it's going, because that was the basis of the lawsuit. Great point
Mhm.
on that, Candace. Okay, now that we know how it's going to be paid, look at little C1 there. And here's what it says. Do you remember if the seller authorized the firm to pay the cooperative compensation? The seller agrees if they do that, that you can advertise that compensation. Now, important for those of you that are in the field, you can't advertise it in MLS. And don't get tricky about this. Don't try to hide it in the wording or anything like that. You do not advertise compensation in MLS. You can do it in your personal marketing. That's fine. You can do that. But the seller's given us permission to market that we're willing to pay the buyer agent because that will attract more showings most likely. But I want you to look at B. B is extraordinarily important here. Any negotiated cooperative compensation must be paid by seller to firm at closing in addition to the firm's fee. So if they give me permission to pay the buyer's agent, on B, they are basically saying that they are going to allow us a credit for that money so that we can, in fact, afford to pay the buyer's agent. Now, look at all that you have put together here. They know how much they're going to pay me. They know how much they're going to allow me to pay the buyer agent. And as Candace said, that fee will not be deducted from the overall fee that they're paying me. As you continue into two there, it talks about if they agree to pay the buyer agent directly, then they're going to do it. I mean, there's the form that we will have them sign at the appropriate time that evidences that they're going to do this. In other words, it basically says, seller, don't leave us hanging. If we say that you're going to pay the buyer agent this amount, you got to do it. You're contractually obligated to do it. And then finally, when we get down to total costs, and Candace, you can look at three there to make sure I didn't miss anything, but I do
I
want to
think
get
we're
to the total
good.
cost because this gets to the point that Candace was making just a moment ago. I agreed we agreed that you were going to pay me X for marketing the property, for listing the property. You agreed that you were going to pay Y to the buyer's agent, regardless of which one of those you chose. The total cost is going to be what you pay me plus what you're going to pay to the buyer's agent plus any marketing fee. So that's the total cost there. And I got to be honest with you, I love this. And the reason I do is that any seller signing this form, if it's been explained to them, there's no way that they can argue that they were not told where the compensations comes from and where it goes. Candace, I'm sorry it took me a long time to say that, but would you wrap that up for us?
Yeah, no, I don't mind at all. And I think that was great. For those people practicing, guys, this is the difference between getting sued and not getting sued. Pre-licensing students, you got to understand this because as of July 2025, this is not on the exam, but there doesn't mean in the future there may not be something like it. These are realtor rules, not commission rules, but you never know. You just never know. You need to understand it. All right, I'm going to go ahead and finish this next section. You've got E. And E is really important because it talks about when your fee is earned. Yes, you're signing an agreement where the seller says, hey, yeah, I'll pay out some money. But why? What is it that you're agreeing to do? Right? And we are saying that if a ready, able, and willing buyer is procured by a firm or cooperating agent or where is it? Anybody else? Then it means you're going to get paid. Does that make sense? I hope so. Remember, if you are in pre licensing, they are going to ask you about the fact it doesn't matter if it's the firm, it doesn't matter if it's a cooperating firm, or if it's the seller directly. You would get paid. You've earned your commission. You may not get it today, the day that you find the buyer, but you've earned it once any buyer is found that meets what they said they wanted in this contract,
Yeah, I would
right?
encourage you, if you're in pre-license class, to make an emphasis to yourself to understand what we mean by the difference between when you earn your compensation and when you get paid. Okay, those are two entirely different things. I bring a ready, willing, and able buyer at the terms of this contract. I have earned my contract. If the seller says, nope, I'm not going to sell, well, to get paid, I may end up having to sue that seller for breach of contract. Okay. Obviously, if it goes to closing, I typically get paid at the closing. So be suspicious, pre-license students. There's a difference between when you earn your compensation and get paid in real estate.
Yep. So I like to point it out this way. You're not getting paid and getting a check to cover these bills, usually until closing. You might find a buyer for a new construction house or something that's newer or something that's, you have a closing that's 3 months later, that's when you're going to get your money. You don't get it right away. So just remember that when you're thinking about your bills and whatnot. Okay, I'm going to jump to this protection period because a lot of times in pre-licensing, this is tested on. This is that protection period that says, look, and let me just say, caveat, as long as this seller does not sell a listing agreement, this whole section, it is really based on the fact that a seller can't sign a valid listing agreement with any other group, because otherwise this does not apply. So that's the first thing. This none of what I'm going to say applies if there's another listing agreement. But if there's not, what the protection period does is protect you and your firm as an agent. It says, look, if this listing ends and somebody who saw the property while we were listing it then decides to buy it, then we get the commission still. If somebody who saw the property while I was listing it buys it after our listing agreement ends, then that's considered, hey, I did my job. I should get paid. But there are some things here we have to remember. One, you've got to choose how many days. And before you ask me, well, what's normal? What's standard? What's absolutely not? I'm going to go with Chris. I'm going to call this a Q. I'm going to say this is Q amount of days, even though it doesn't have to do with money. What I'm trying to say is it's whatever you and the seller negotiate. It could be 1 day. It could be 50 days. It could be 180 days. It's whatever you all choose. But for that time period, if a buyer who saw the property while I was listing it buys the property afterwards, I get paid. But also, I have to give the seller a list of names. It says within 15 days, within the expiration date, I've got to deliver a list of names of anybody who would have seen the property that could buy it. It's just not if anybody buys it. I've got to provide a list of names of people who saw it while I was listing it, and no new listing agreement comes into play. And then I would be covered. So it seems very small, but it actually is a lot. You've got a lot to do to be protected, which I think is fair. Chris, you want to add anything there?
I do actually, even though that I consider this to be one of those paragraphs that I don't put a lot of thought into. But what Candace said is there's a lot of moving parts in this particular one. Fortunately, once you know it, you're actually in pretty good shape on this if you know that this exists. But Candace, what I want to do is remind them that this is also known by a couple of different names. It's also known as the override clause, or the extender clause. Okay.
Yep. And
The
I
protection,
love a good synonym. That's why I
yeah,
have that list of synonyms available.
yeah, protection period, override, or extender all mean the same thing. However, one last thing to look out for, we actually have another agreement that's referred to as a protection agreement, and that is not this. The protection agreement is something you use when you're working with a for sale by owner, for example. And so the point I'm trying to make is there's enough language here that'll just drive you nuts. Fortunately, it's a great flashcard word if you're trying to learn this for pre-license.
hmm You definitely want to remember all those synonyms. So many synonyms in this industry.
Yep.
Okay. Well, we talked about this already, Chris. This is not due and payable. We earned it, remember, up here, but it's not due and payable until usually closing. Now, if the seller defaults, that could be something different. If the seller goes off script, does something, I don't know. There's all these other things that can happen. But really and truly, expect to be paid at closing, or I should say after closing. Because remember, there's a difference between settlement meeting and closing. Closing is after the settlement meeting, they do a title update, and then it's recorded. You don't get paid until it gets recorded. Anything else you want to add to that, Chris?
No, I think that's sufficient. We kind of touched on that earlier, so I'm good with that.
All right. This transfer of interest in business entity basically says, look, if you are selling a property that's owned by, multiple people and one of those people sells off a share, What happens then? Now, since, most of you all in pre-licensing are not going to be tested on the details of this, but Chris, you said something, you explained it pretty well the other day in that class. What did you say?
Oh gosh, I don't remember exactly what I said, but the one I usually use goes something like this. You have three partners to an entity, could be an LLC or something, members, managers, whatever it is. There's three of them. They're thinking about putting on the market, and one of them says, "Well, why don't I just buy you out?" After they list the property, one of them says, "Why don't I just buy you guys out?" Well, you may look at that and say, "Well, that wasn't really a sell. That was one of the managers who's buying the other two out." Well, that is a sell because you listed this property, you marketed this property. What you would be entitled to is your compensation for the two-thirds that did sell based on what the fair market value currently is. So that's an example of how it might come up. And the idea is to protect you. I mean, think about this. You may have had this property listed for a year, and now all of a sudden one of the investors tries to buy the others out. It doesn't mean they can circumvent paying you your compensation.
Exactly. All right, let's keep on going. You've got a home warranty. Sometimes a seller provides a home warranty. Sometimes a seller does not provide a home warranty. This is a discussion for you to have with your seller as the agent. And whatever you decide, go ahead and check one of those boxes. Don't forget, though, if they say yes, then you may want to talk about who it's going to be, how it's going to get paid. There's lots of conversations, but a seller doesn't have to provide a home warranty. It can be used as a marketing, just to get people in. It can be used because you think the house is older or might need work. So many reasons to do it or not do it. Just make sure you have a conversation with your seller. Right? And along those same lines, sometimes the seller may want to do a home inspection before it goes on the market. I'm always a big fan of that, but not everybody feels that way. A seller could do a home inspection before they put it on the market so they can figure out, okay, are there things I want to fix before I put it on the market? Or if I know there might be something that comes up, I could use it as part of the negotiations. I will know how much these fixes will cost. So at the end of the day, my net is where it needs to be. So they just decide they either do or do not agree to obtain and pay for a pre-marketing inspection. And of course, that relates to your material facts. Remember, sellers, in theory, don't necessarily have to tell any material facts. That's a very loose statement. But agents, you do. So if you are told about a defect in the property from a pre-inspection report, then that's something you got to share with everybody moving forward if the seller doesn't fix it. Chris, anything you want to add there?
Just it's more of a tip really than anything else. I was talking to a litigation attorney a while back, and one of the things he said is that it's getting very litigious out there now with buyers suing sellers if something is uncovered in the inspection, and then they're on the risk of losing their due diligence and possibly earnest money as well. They're starting to sue sellers for this. This litigation attorney, one of the things that he advised is if you do a pre-inspection, he said attach it to the Residential Property Owner Association disclosure statement. He said that is one of the ways that you can argue in the future that, hey, I'm clearly not hiding anything. I even had an inspection done for you, buyer, if you want to take a look at that. I will say that not all sellers are going that way, but to Candace's point, home warranty and pre-marketing home inspections, I know they seem minor, but you need to have conversations about these either from a marketing standpoint or from a CYA standpoint.
Exactly. All right. Our next section is earnest money and due diligence fee. Now, we talk extensively about this in the offer to purchase video, but we know that earnest money deposits, those don't get held by the seller. That's got to go into somebody's escrow or trust account. And the due diligence fee, if the buyer's paying a due diligence fee, that is supposed to go to the seller directly. So we've got to give this seller some information. Hey, does my firm even have a trust account to hold earnest monies? Some firms, I will say a lot of firms in the triangle are like, yeah, we don't want to hold trust monies. We don't have an account for that. And that's fine. We can have an attorney or title company hold the monies. I mean, it's possible. That is something that could happen. And then you want to talk to your seller. Okay, well, what happens if the buyer does default? And this will be after due diligence. And now you, seller, get to keep the earnest money. In the contract, it provides, if you want to, that if the buyer defaults on the purchase contract, the seller could either agree or not to agree to split any earnest monies forfeited by the buyer. So you can have an agreement with the seller that says, hey, if you get an earnest money deposit because the buyer defaulted, you know what? You should get half and I should get half because, I've done some work here too. And then here's where you're going to approve any due diligence fee will be either paid to the seller or I guess the seller, if they really wanted to, could go it someplace else. But usually it's going to be paid directly to the seller. And I think that's going to be all of the major points. Anything you want to mention there, Chris?
Yeah, this whole thing about who due diligence is going to be paid to is getting to be an important part because if you're dealing with couples that are divorcing or heirs to an estate, if there's four heirs to an estate and there's $10,000 in due diligence fee, they're going to want it as 2,500 apiece. And so they need to let you know so that you have permission to go to the buyer's agent and tell them how to make out the checks.
hmm And this is where, if something like that happens, call your attorney, talk to your BIC, make sure you're filling this thing out correctly. All right. Now we've gotten to the dual agency section. Dun, dun, dun. The dual agency section. Why? Because we said at the beginning of this whole video, this is an exclusive right to sell listing agreement. This is creating exclusive or single agency between your firm and that seller. But your seller may want other agents in your office, other agents that are part of your firm. So if you're with a company that's got 3 different office locations or 17 different office locations, it could still be one firm. You might literally have hundreds of agents. If that seller wants any of those buyer agents or these buyers represented by agents with your company, we have now hit dual agency. And I happen to know Chris's office, which I'm also a part of, is a wonderful office. We have great agents. So there's a good chance, because there's so many wonderful agents, that if I'm listing a property, Chris might have a buyer that wants to see that property. And the only way that can happen is if both the buyer and the seller agree to dual agency. So just as a wrap up, remember, this form as a whole authorizes single agency. And the back part of this form says, hey, if it comes up, seller, are you okay with dual agency? So, Chris, do you have anything to add about what dual agency is?
No, other than the fact, I think the form is really well written to describe what dual agency is. The Real Estate Commission actually has a pamphlet on helping you explain this if someone has a problem. And in our office, as Candace said, in our zip code, we literally have an agent involved in 70% of all transactions that occur in that zip code. There's no way that our clients are not going to be in some form of dual agency. So they need to be competent in explaining this. And as Candace describes the options to you here in just a moment, I'm going to give an example of a question that we had last week and tell you why this is important.
Okay. So I'm going to jump down, just down here. There's some things, I think it's easier if I explain the options, but I do want to point out not every real estate firm offers dual agency or designated dual agency. This is going to depend on your firm that you are with. However, it's important for you to understand all of these options. So once you talk to a seller about, okay, this is what dual agency is, the seller has to make a choice. They're going to choose one or the other. Either the firm may not act as a dual agent in the transaction, or the firm can act. They may act as a dual agent in this transaction. And I want to point out they may. there's a chance that the buyer is not represented by somebody in your firm, and then you don't need dual agency. This is about what if this happens? If it happens, if it happens, either the firm may not or they may act as a dual agent. They're only going to choose one. They're only going to choose one of these lines and they would initial. So maybe I choose to go with this one. Now
Uh,
that I've tried to go with it,
let me mention this, Candace, because using my office as the example on this, if one of my agents bought back a listing agreement and they said that they may not act as a dual agent in the transaction, I would actually question how well they explain that to the seller. Because remember, we're such a high percentage of the transactions in that area. They're basically saying that none of our buyers would be able to see the property. So just something as simple as that helps us understand whether the seller and our agent understand dual agency.
yeah, I agree. I get it. All right. So let's say, Chris, you are trying to be my listing agent and I authorize dual agency. Great. I signed that bottom line or the second line. Now that I've chosen dual agency, I got to go and dig a little bit deeper. It's like you decide to go to dinner. Chris, you might decide to buy dinner for me. Yay, that's one decision. Now we got to decide what we're going to eat. What is this going to look like? Are we going for Mexican? Are we going for Asian? Maybe some sushi? Are we going for pizza? What does it look like, Chris? Because yes, we've agreed to something, but now let's narrow down the details. Yes, I agree to dual agency. But now this seller needs to decide, hey, if Chris, you're my listing agent, can you represent both the me as the seller and the buyer and dual agency? Can it be one agent, just you? You're talking to me. You know my secrets. You're talking to the buyer. You know the buyer's secrets. Am I okay with you representing both of us? Now, just as a reminder, if I say this is okay, Chris can't tell either of us any kind of confidential information about either side. He basically has to be like a referee. He can't give more help to one side than another. So that's something to talk about with your clients. But yeah, this could happen. And I, as the seller, have a choice. Hey, am I allowing this to happen? Or am I not authorizing the same agent to represent both myself and the buyer? Now, if it was me personally, I'd probably check this one. I won't even lie. I like this idea right here. But I have the choice to say, am I going to allow the listing agent I'm working with, Chris, to represent and be in conversations with the buyer? Or do I want Chris only working with me? And if it comes up that we're in dual agency, I want another agent in his firm to represent the buyer. That's what I would want. But of course, it is up to your clients.
Mhm.
This second one, if somebody is chosen, you can act as a dual agent, but they don't authorize the same agent to work with, the buyer and the seller, then you might end up in designated agency. You might end up in designated agency because, guys, remember, even though I'm about to explain it, both the buyer and the seller have to agree to designated agency or nobody gets designated agency. So, what is designated agency? Well, look at what this section says. The seller does not authorize the same agent to represent both a buyer and a seller in dual agency and directs the firm to practice designated dual agency. If the seller directs the firm to practice designated dual agency, then the firm will practice designated dual agency unless it's not allowed under law or the seller authorizes the firm in writing to practice dual agency only. So, guys, let me tell you what this means. If your client sells this one, you stay in dual agency as a firm. It's kind of almost like this one, where you're not getting any secrets or nobody can really tell you anything that's going to give you a leg up. If I want that leg up, If I want help, if I want Chris to be able to act like my single agent, as if he was my listing agent, then I would need to sign or initial here. If I want designated agency, this is the line I would have to sign. Now, that doesn't mean I'm guaranteed designated agency because we got to get that buyer to authorize designated agency. But if at all possible, I'm saying, hey, if we get up in dual agency, you know what? I want designated dual agency if possible. If I just want to make sure that Chris is only working for me and not talking to a buyer at the same time, I could check that first one, this one, or let's just say the second one. That's a possibility. But there you go. Chris, what do you want to add to that?
Okay, here's what we have found in the office, Candace. And again, I'm speaking to my office, and I'll tell you why we might be different from some people. What we have found is most sellers are okay with dual agency as long as it's not the same agent representing both the seller and the buyer. So very few check the first box. I do have some really, really large agents who like dominate neighborhoods. Some of their sellers are okay with the first one, but I will say 90+% of sellers and buyers, they just don't like the first one. It has to do with the conflict of interest, and I will tell you from the standpoint of errors and omissions insurance, dual agency transactions are one of the most litigated transactions that there is. So I don't love number one. Number two, as Candace said, I'm okay with number two. Technically, the second one is the same as the first. There just happens to be two agents involved. And the reason I say it's kind of the same is you have the same obligation. You keep all but everybody's keep everyone's confidential information confidential. You still pass on material facts just like you would have to do anyway, but you can't advance either party's interest over the other because even though there's two agents involved, they're in a true dual agency situation. Our firm has a policy of designated agency. So if our agents check anything other than the third box or have it initialed by the seller, anything other than the third box, we have a conversation with them and say, okay, do you understand our policy on this and why is it a little bit different? I told you I was going to tell you a quick story on this. And one of my seller clients the other day, one of my agents came to me. He was talking about a seller client. And his seller client said, I don't feel really good about this idea about there might be some information exchange within your office which could affect my marketing position or my negotiating position. And my agent said, well, what should I tell him, Chris? I said, well, if he chooses designated agency, you are forbidden by law and the rule of agency from disclosing any of his confidential information, even within the office. So by choosing designated agency, my agent acted as if he was his exclusive agent. And if another buyer from our office comes in, they will be represented, and that agent will act as an agent designated specifically for the buyer. And by virtue of that, there's a wall of separation where the buyer's confidential information is confidential, the seller's confidential information is confidential. The firm will still be a dual agent, but the individual agents will be designated. Very, very workable if you can explain it to your clients.
If you can explain to your clients, you know what? Sadly enough, I have agents that have trouble explaining it to me as a teacher. But it is important.
True.
It is really important for agents to understand this. And for my pre-licensing students, you're taking a test to become a person who's licensed to be an agent. Of course, they're going to test you on agency. You need to understand this. You know what, Chris? Maybe we should do a video breaking down agency one day.
I
Like, really
think
just doing.
probably so. And I'd like to be able to talk at length about dual agency. And I've actually had attorneys in my class, Candace, that had a problem understanding dual agency as it's conceived in real estate because it's different in their
Mhm.
industry.
Yep. All right, we'll work on that. We will. All right. I do want to point this out because you said it, Chris. Regardless of whatever type of agency is authorized, we always have to disclose dual material facts to all parties in the transaction. So we got that. All right. Section 12, disclosures and representations. These are things that you need to be having conversations with your seller about. Some of these are things you just need to know, and the seller needs to discuss with you so that you can make sure this transaction goes through smoothly. All right. Now, are there any things on here that you think are really important? Because if you think so, let me know. But I like, especially this one, has the seller received sample copies of the purchase contract and the professional services disclosure form? That professional services disclosure form is a piece of paper that says, hey, seller or buyer, you can use it for a seller or buyer. There are inspections that you can get. Did you want to get those inspections? I'm telling you about them, but did you want one? Yes or no? And if you say yes, just remember you're paying for it, not me. I think it's a really important form, and I think it's important to give a copy of the purchase contract as well, but I think that's something we should talk about. On the contract, you're going to have to say whether or not the sellers own the property for at least a year. And if the seller doesn't own the property as of yet, you need to have a discussion about that. Is it a mobile home? Where did I say? Or does the land itself have a mobile home on it? Because if it's a mobile home and hasn't legally been made into real property, you're now selling real estate with a piece of personal property. Anything else that you want to talk about here, Chris? Maybe
I,
the talking about making sure if there's any restrictive covenants.
yeah. I would encourage agents to literally go down this list one by one. And what you'll find is it gets a little bit boring because sometimes you're like, well, it doesn't have a mobile home on it. What's the point in asking this question? Well, remember, this contract is written for people all over the state of North Carolina, all types of residential properties. So if you get to one of these things and you're like, it doesn't apply to me, that's fine. Keep reading because there's a decent chance there will be one that does apply to you. And the one about whether the buyer, I'm sorry, whether the seller owns the property yet or not, if they've owned it for less than a year. Look, if they've owned it for greater than a year, this is not an issue. But if it's less than a year, it could affect the buyer's ability to obtain financing on that property. So there are a reason that these are being asked. And you just need to go and check the buy. So I'll look at that first one. The first one doesn't seem like it's an important question. Seller's not working with a relocation company, but Candace, relocation companies are now charging huge referral fees. And as a listing agent, you need to be prepared for this because it could affect the amount of money that you're going to put in your pocket. You would rather know that now than when you get to the closing table and see that a huge chunk of your money has gone to someone else. So I find them all to be important when they're important. If it doesn't apply to you, just check no and keep moving.
It's like insurance. Nobody cares about insurance until you need insurance, and then
Right.
it's really important.
Yep.
All right, I'm going to go through and just point out, remember, as agents, we have a duty, whether you're the buyer's agent or the seller's agent, to pull up some FEMA maps. But you want to talk to the seller. Maybe they already know that they're in a flood zone. Maybe they're already getting flood insurance, but that is something you need to know. You need to talk to your seller about whether or not the property has ever had synthetic stucco, because as far as the commission is concerned, whether a property currently has or has ever had synthetic stucco, that is a material fact, right? I'm trying to think, is there anything else here? I mean, if the person's going through bankruptcy, you would probably want to know. You definitely want to talk about if there's any special assessments that are improved or under consideration. We talk about that in the offer to purchase thing. It's a thing, the offer to purchase and
Mhm.
contract video. And if there is currently a deed of trust or a mortgage or a HELOC or whatever it may be, if there are any of these type of financial liens on the property, you need to know. Every so often we hear stories about sellers that get right up to the day of closing and then realize the closing amount's not going to be enough to cover all these monies that are owed. And that's when you definitely want to talk to your BIC and an attorney. Right?
Yeah, this part right here is kind of like going to a doctor and they're taking all the tests. These tests that you were asking the seller on right here are to find out whether they have the ability to convey title or if something is going to come up that's going to affect their ability to convey title in a timely manner.
Mhm. All right. Is the property subject to a lease? Has it had an FHA appraisal within the last 180 days? Is there a fuel tank on it? Seems a little crazy, but people get real tense about fuel tanks and who owns it and who's going to get the fuel in the tank. It's not crazy, but there's a lot of details there. So just make sure you talk about it with the seller. All right. If you've got separate septic situation or a boat slip or garage or parking space or any or storage unit, anything that's like a little bit extra, you want to talk about this with the seller. You don't want surprises once you're under contract. And the best way to not be surprised is to ask the seller while you're doing the listing. And if there's anything else that we maybe missed on this list, we've even given you some blanks so that you can fill it out. So did I cover everything major there, Chris?
Yeah, and now you did skip the one about the being in violation of any law
Oh,
or ordinance. Guys, watch out for unpermitted square footage, okay?
mhm.
Because it would fall into this particular category. But like we mentioned a little bit earlier, this is a list that I would literally just go down and ask the seller because what it does is it triggers a conversation. You're selling a condo or something one day, and you ask about the separate septic, boat slip, garbage, garage, parking space. They're like, oh yeah. I own a condo here, but my parking is across the parking lot in garage U2. That's the dedicated parking space for my garage or for my condo. Just knowing stuff like that and being able to make sure that the buyer is aware of it so that it fits their needs is huge. If it
I
comes
think it's hilarious. You said it's parking space U2. Does it come with the band too? Are we going to have people singing?
Be
I
careful
want
what
to
you
point this out, and this is for my pre-licensing people and people who've already um, finished and you're practicing. A lot of times we'll hear people say, why do we even have to go through pre-licensing? We don't ever use the stuff we learn. That's not true. You learn in pre-licensing about things like UCC filings, right? We talk about things like mechanics liens. We talk about taxes and defaults and foreclosure. We talk about FHA loans. There's all these things that, you know what, you might not talk about them every day with your clients. But in order to do your job and to understand these contracts, you've got to know what they all are. It may feel like you're not using the information that you learned, but you most definitely are because you understand what the contract says and what they're talking about, what they're referring to. So that's just a
you,
little thing I like to say.
the UCC filing came up this year in our update class because we're starting to see it come up in regards to finance solar panels.
Yeah.
So it is a big deal.
And just go ahead, Chris, remind them what a UCC filing is, just in case.
It stands for Uniform Commercial Code, and it's an item that appears to be a fixture, but it remains the personal property of the financier until the financier is paid off. So when you have solar panels that are financed by this company, technically speaking, they maintain an interest in that property until it's paid off. If you stop paying for those solar panels, let's say, for example, a buyer buys a property not realizing there's a finance payment that needs to be made. If they don't make that payments to the finance company shows up and takes those solar panels down, and now we got a lawsuit. And we've had enough of these cases come up that the Real Estate Commission put it in our update course this year.
And when we say filing, we mean at the Register of Deeds.
Yes, thank you.
All right, let's scroll on to the seller's duties. I mean, we have talked extensively about all these things relating to us and what we're going to do for the seller, information we need to know. But guess what, seller? You got some duties too. They have to cooperate with us and make sure that they give reasonable access to the property so that the buyer can do inspection, so that we can take a look at the property and make sure that's going what is going on. And they're agreeing to deliver a general warranty deed at closing and follow anything that they say they're going to do in the purchase contract. Fine. I like it. Our next section is about surveillance, photos, and photographs and videos. Now, this is what we brought up a little bit earlier. It is illegal. It is illegal in North Carolina to record somebody's conversation with another person if you didn't first get their permission. This is a big deal. So again, talk to your sellers about the fact you want to record video, knock yourself out. You want to record audio, that's not good. Do not do that, right? But you also want to have conversations about photographs and videos that are taken for the purpose of marketing the property. I mean, you definitely want to read this paragraph and make sure you understand, hey, am I paying for this? Are you paying for this? What can I do with it? What can I not do with it? What things do you want videoed or not videoed? There's just a conversation to be had so we're all understanding and all on the same page. Anything else you want to add there, Chris?
Now, even in recording video, be careful about that and make sure that your cameras are in what you would consider to be public places. In other words, even though you can record people in your home, you can't record them if they have to go to the bathroom, for example. And then also, sellers, use some common sense because there are going to be pictures taken. There might be buyers in your house that are taking pictures. Put away your jewelry, put away your guns, put away things like this. It's a great conversation to have with your clients.
Hmm. All right, moving on. You got one of my favorite sections, other professional advice. This is us as an agent being like, looky here, seller. I am a jack of all trades and a master of none except real estate. I know a little something, something about plumbing. I know a little something, something about electrical. I know a little bit about law. So I can't be your professional on this. If you want more information on taxes or financing, insurance, wood destroying insects, like all these things, engineering, you need to hire that professional. You need to hire that professional and pay for them. Right? So this is just telling them, hey, I know a little bit about a lot of things. So, but you can't rely on me for all of your knowledge. Anything else you want to add there, Chris?
Just be careful when you order these inspections for your client. Make sure, in fact, that they are going to pay for them, and in fact, make sure they're going to pay for them even if the deal falls through. Now, this happens a lot on the buyer side, not as much on the seller side. But sometimes when a deal doesn't go to closing, they say, well, I was going to pay such and such at closing. If it doesn't close, they still have to pay for that inspection. Otherwise, these inspectors start coming and looking at the agents and saying, hey, you ordered it. We expect you to pay.
Mhm. All right. As part of North Carolina rules and laws and everything, we would have learned about the fact in North Carolina, when a buyer puts an offer on a property, the details of that offer cannot be shared by any other real estate agent. So if I'm the buyer and I give an offer to a seller, neither agent can share the details to any other buyer without my written permission, my express permission. Right? So basically, you got to keep details of offers confidential. I do want to point out, though, the seller is not under those same rules. The seller does not have a real estate license generally. So if the seller wants to tell your details, that's on them. But we as agents cannot share the details of a buyer's offer without express permission. Right? And on the flip side of that, remember, a seller may choose not to tell people that there are other offers, that you're in a multiple offer situation. Sometimes buyers, when they find out there's multiple offers, walk away. And that's not necessarily what they want. So if you're a buyer's agent, talk to your buyer about the fact the offers are confidential as far as agents are concerned. If you're a seller's agent, have a conversation about whether or not that seller is comfortable with telling any offers that come in, oh, this is a multiple offer situation. Chris, talk to me about this wire fraud warning. It's in red, man. I mean, it's got to be important.
Yeah, not only is it in red, but it shows up in all our agency agreements, all of our contracts right now. And I was watching a video the other day on the top scams in real estate. It is still the top scam in real estate, according to the attorney that I was watching. And agents, here's what I'm advising you on this. You have got to get with your clients and say, you never send wiring, you never send money to someone that you haven't independently verified. And by the way, you will never get wiring instructions from me, the agent. I am not involved in this. This is you sending it to an attorney or bank or whatever it is. And what you need to do, client, is pick up the phone before you wire someone money and verify. And don't call the number that you got in the email, because obviously if someone's sending you a fraudulent email, they're going to answer the phone and tell you it's the right one. Go to a business card that you got from the attorney, or go to the whatever, the phone book or the internet, whatever you use to find out what that attorney's direct line is, and call them up and say, hey, I'm working with paralegal Casey. I just want to find out, did you in fact send me wiring instructions? And then you can validate that this is no BS. I mean, we have got to stop this because when people lose money through wiring, they are not getting it back for the most part.
hmm I mean, it's serious enough that look what it says. The seller understands there are risks associated with wire transfers that are not within the reasonable control of the firm, and the seller agrees to release and discharge the firm and the firm's agents from all claims not caused by gross negligence relating to a wire transfer associated with the services. Um, Nobody's trying to get sued for this. Make sure your seller understands the seriousness of confirming the information they get for wire transfer. And you should probably stay out of it. Don't you get involved. Go ahead and tell your seller and your buyer, I will never send you wiring instructions. Ever. Never, ever, ever.
I will tell my agents this, Candace, and then they'll come up to me and ask this, and they'll say, I just got the wiring instructions to the bank. Do I just forward those to my client? And I'm like, no. Have you not been listening for the last 8 years?
Don't do that. All right, if there's anything that is additional, something that hasn't been addressed that you need to add to this, you may do that because you are a party to this contract. So that's fine. And then you've got all of this kind of legalese in this paragraph: merger, termination, modification, assignment, blah, blah, blah. And that's basically, it's the legal stuff you normally see. And then section 21, non-discrimination. You cannot discriminate. You cannot discriminate by law. And if you're a realtor using this form, by the code of ethics, you cannot discriminate. And the commission is going to require this non-discrimination language in all agency agreements. Just do not discriminate. It's really kind of easy when you think about it. Just don't do it.
Yeah, this is fairly standard language. And a lot of times when I'm teaching pre-license class, I talk about the rules of agency agreements. All agency agreements must be in writing, signed by the parties charged therewith. It must have a start date and an end date. It has to have non-discrimination language, pretty standard language that you see here. And in just a moment, you'll see the final thing where it has to have your license number as well. I bet when we get to this last page, you'll see a spot for your license number.
Mhm.
Why?
Here it
Because
is
these are
right there.
all rules of the real estate commission.
This is the firm and the firm's license number. This is the agent and the agent's license number and a date, and then your address and all that information. And here's where the sellers could sign. And if it's an entity, this is where they would put that information in. And with Chris, I think with that, we are on page 7 of 7. I cannot believe we got through all that, and we do this every couple years, but this was a good one. This is good information. I do think these changes have made the listing agreement and the other changes in the buyer agency agreement and the offer to purchase and contract. I think it makes things a lot clearer.
Yeah, it took us a little longer to go over that than I thought. This form has been dropped from I think 11 pages to 7 pages or something like that. It's certainly 7 pages. Now, don't worry, you haven't lost a lot. What they've done is they've consolidated some of the provisions. They've put some things in almost more like bullet point format, but you really haven't lost anything from the previous form. But by virtue of the new typeset, it's down to a 7. It's much more understandable for your clients, and there's less pages where you can go, don't worry about that, don't worry about that, don't worry about that. Most of the stuff on here you will have time to work through. Candace and I worked through it pretty seriously over the course of about an hour, and I think that's probably close to a reasonable amount of time that you would spend with your seller going over this form as well. Send them the forms ahead of time so that they can kind of look over these, and then that way they can keep their questions to the ones that are most pertinent to them.
Exactly. And I would be remiss if I didn't point out this is the July of 2025 form. Usually every July in North Carolina, these forms that are provided by the North Carolina Association of Realtors, they change. But it could change earlier than that. You must use the new forms, the newest forms. So just make sure you keep an eye on that. If this is 2026 and you're listening to it, look for mine and Chris's video on the newest form. So there you go. All right, Chris, thank you so much. I think we did a great job. I really hope this was helpful for everybody. Any final words?
No, it's just, I think you're right. I think this was a thorough going over, regardless whether you're pre-licensed or in the field. And then make sure you know how to get in touch with Candace or I or both, and we can help you with details on those. Watch for changes coming to this as we evolve based on the lawsuit that occurred last year. But I'm guessing that they will not be major. They will just be tweaks. So don't panic. We'll keep this short and simple.
All right. Well, we'll see you next time. Bye,
All
everybody.
right. Bye bye.